Good afternoon. I'm seeing you all in another courtroom. Musical chairs today. Please be seated. This is my sit-in for this courtroom, this one case. So the case we have on the calendar for now, R.J. Reynolds Tobacco versus Vina Clay. Counsel, you may proceed.
Good afternoon, Your Honor. May it please the Court, my name is Donald Ayer, appearing on behalf of Appellant R.J. Reynolds. I'm actually appearing pro hoc vice with Charles Bell at counsel table. And also with me today is Karen Curtis of the Clark Silverglade firm, here on behalf of Liggett and ready to answer any questions the Court may have. The plan is not that she would argue, but that she's available if you want to ask her questions. We have raised, oh, and by the way, I'd like to reserve 4 minutes of my time for rebuttal. We have raised 5 issues on appeal, and I would like, if the Court will allow me, to focus on 2 issues in particular that we think are particularly meriting of discussion. The first one is what we submit is the Court's error below in failing and refusing our request to instruct on the issue of the statute of repose. And we submit that that error entitles R.J. Reynolds and Liggett to at least a new trial. Florida's statute of repose, section 95.031, subsection 2, states, quote, that an action founded upon fraud must be begun within 12 years after the date of the commission of the alleged fraud, regardless of the date the fraud was or should have been discovered. Since the plaintiff here was found to be an Engle class member, this means that she has a filing date of May 5th, 1994, when the class action in that case was filed. And thus we submit that the statute of repose bars actions for fraud where the fraud was committed more than 10 years before, prior to May 5th, 1982. On that basis, Reynolds and Liggett requested and were denied an instruction addressing the statute of repose, which would have barred consideration of evidence with regard to frauds for concealment where the fraudulent conduct occurred prior to May 5th, 1982. And we submit that that was error, first of all, because the 12-year period applies.
So when did the fraudulent concealment occur?
Well, you know, our position is that there was, in this case, no fraudulent concealment proven, in the sense that there was no proof of, there was a pattern of conduct that went on, but we submit there was no adequate proof of reliance in this case. And that is an issue on which we think the evidence is clear, but the important point with regard to the statute of repose is that the jury was instructed that they needed to find reliance. Notwithstanding our contention, they did find reliance. But the important point on statute of repose is, when did the fraud occur? And on the facts of this case, we're dealing with a decedent who began smoking in 1958 at the age of 14, and who by 1982 was way past the point in time when she was making decisions whether or not to smoke. We submitted a substantial amount of evidence, and there's a substantial amount in the record. We discuss it at pages 20 through 24 of our opening brief, indicating that she was aware of the dangers of smoking. Certainly she was aware of them by the time she'd been smoking for an extended period, you know, which is to say, by the time of the repose period. And all we need to show, I would submit, in order for this to have been an important error in not giving this instruction, is that there's a real issue of fact as to whether any fraudulent conduct occurred that she relied upon, during the repose period. And we think the record as a whole is quite strong that, in fact, we submit that she didn't rely at all because she always knew, but certainly by 1982 she knew, and there's simply nothing in the record that suggests she was relying on anything that occurred after 1982. And so
isn't this a jury question, counsel, as to when it occurred or if it did not occur?
It is, Your Honor, and that's our point, is that the jury needed to be given an instruction with regard to the statute of repose as was done in the Hess case, which is currently pending on appeal, to determine when the fraudulent conduct occurred. And we simply never got a decision from the jury on the issue. We did get a decision from the jury as to whether or not there was reliance. But we didn't get any kind of a determination on the statute of repose. And we think that's a significant error that requires reversal. Now, the argument that's made on the other side with regard to that is that allegedly there are some cases that in certain contexts address the question of continuing torts. There's the Lashkey case, there's the McLeod case, and there's the Ambrose case. And those cases are argued by our opponents as a reason why you essentially don't even need to have any kind of a decision on the statute of repose. But we would submit that those cases don't stand for that proposition at all. All those cases did was to find that all of those were cases where summary judgment had been granted for the defendant, and the court reversed a finding for the defendant on the statute of repose on summary judgment. Those cases don't say that the statute of repose isn't a fact question, whether something occurs within the statute of repose. And they certainly don't say that you're not entitled to a jury instruction with regard to the statute of repose. The second issue I want to address, and I may reserve my time to respond when my opponent gets up and argues.
Counsel, Mr. Douglas, back to the first issue again. The parties have stipulated that Mrs. Clay died from COPD, is that correct?
That's correct.
Now, this condition is considered a latent creeping disease, a disease that's acquired over a period of years as a result of long-term exposure, is that correct?
That's correct. But with regard to the statute of repose, all we're talking about is when the alleged fraudulent concealment that she relied upon took place. We're not talking about when the disease commenced. We're talking, this is not a statute of limitations argument I'm advancing. This is an issue about when, and the statute deals specifically with claims for fraud. And so the question has to be, when was the fraud on the decedent committed? And that was a jury question. That's what we submit. It was a jury question, and we needed an instruction. The jury was told nothing about the statute of repose, not one word about the statute of repose. And we submit that entitles us to a new trial. The second point I want to touch on here in argument, and I'm perfectly willing to submit the rest of our arguments on the briefs, concerns, of course, if the fraudulent concealment and conspiracy verdicts are reversed on the basis of the statute of repose issue, then the punitive damage award also would be reversed, except for the issue they raise in their cross appeal, which I will defer, if I may, and respond to after they advance any argument they may make on it. But even if we were not to win on this statute of repose new trial argument, there's still a serious problem in this case with regard to the punitive damage award, because punitive damage here rested on evidence and argument that wasn't properly responsive to the case of the decedent in this case. Specifically, the most important point here is that substantial evidence was introduced, and it appears at transcript pages 1286 through 89. Substantial evidence was introduced with regard to youth marketing practices that occurred, according to this evidence, beginning in the 1970s. Which was long after, in 1973 when this begins, the decedent was at that point 28 years old. And the youth marketing evidence that's in the record, both in evidence and then argued vociferously in the opening closing argument for the plaintiff, was evidence that had to do with the physiology of adolescence. It had to do with the idea that the tobacco industry was working and writing memos that were working to try to addict young adolescents at a time when their brains were in a formative plastic condition that addiction could be achieved more directly. And those were the sort of the subject matter of this youth marketing in the 70s. Well, by the 70s, the decedent in this case was not a youth. The marketing practices discussed in the 70s, which there's no indication had occurred before. There's no evidence of this same kind of a conversation happening in the 50s, which is when Mrs. Clay was in fact making the decision to smoke, and if she became addicted, when she became addicted. The evidence was only much later. And we would submit that the offering of this evidence and the argument of it as a ground for awarding punitive damages was an improper ground. And the reason why is under the United States Supreme Court's Williams case, you can only punish people for conduct that is relevant. You only award punitive damages to a plaintiff in a case where the conduct has bearing upon and is of the character of the harm that they suffered. And so this youth marketing evidence from the 70s is not in any sense evidence that had bearing on this defendant. We would submit that it's very emotional evidence, that it tends to influence a jury, and that it shouldn't have been allowed to be considered. We objected to its admission in evidence. We didn't object to the argument because we'd already objected to the evidence, and our objection at that point was overruled. The evidence came in, and having come in, we weren't in a position where we could argue that it shouldn't be considered. So we think we preserved this argument. If the court's agreeable, I'd like to save the rest of my time.
Fine.
Thank you very much.
Good morning, and may it please the court, John Mills on behalf of Fenna Clay. I'll go in reverse order if I can, because I think that last argument is easy to dispose with. I would challenge the court to ask for a citation to where they made an objection to that evidence in the record. I haven't found any objection to youth marketing evidence in the record. And there was no objection to closing argument regarding youth marketing. So I believe that the objection is waived as to the evidence, and they did raise it in their motion for a new trial on the closing argument issue. So that would be governed by the standard of Murphy, which means they have to prove that we could not have won this trial but for that argument. And I think this court has affirmed enough Engle verdicts to see that you can win these trials just fine without anything improper. Even had they preserved it, the argument is utterly without merit. The first youth marketing evidence that went in, and the most important, was regarding youth marketing evidence to Miss Clay. Miss Clay began smoking in the 1950s and 60s, late 1950s, early 60s. She began smoking, the evidence tells us, because that's what she saw everybody else was doing. She liked to watch TV a lot. Her favorite show was Gunsmoke and the Beverly Hillbillies, which were sponsored by tobacco companies. In fact, Gunsmoke was sponsored by the L&M brand. And Liggett, there's all kinds of evidence about Liggett bragging at the time how they had blanketed the airwaves to show the ubiquity of smoking. And so here we have a young teenage girl.
But that's not youth marketing, is it?
They also advertised on the Flintstones. Fred Flintstone, that's part of the conspiracy. Fred Flintstone smoked Winston's, all the children's shows, and all of the things that were directed to the youth, to kids in particular. There was also substantial evidence about continued youth marketing. That is extremely important and relevant for the punitive damages, and that is important to show the reprehensibility of their conduct and that they have not, contrary to the position they take in the litigation in this and every case, they did not reform their ways. This is not bad youth marketing in the past, and they've stopped doing it and don't need to be punished anymore. It continued for decades and decades, and in fact, they got better at it as they did more scientific studies. You just heard him explain what they were, about how the brain works and how you can't get replacement smokers if you don't get them before they turn 23 or so. Really, you need to get them before they're 18 or 19. That's when most people start smoking. Another group starts smoking in their late teens, very, very early 20s. almost nobody starts smoking after that. And so that's always been their focus. And the jury was presented substantial evidence without objection about that. So there's nothing wrong with that evidence. That's why they get hit with big punitive damage awards, because this is a continuing course targeted at children and the public in general to conceal the dangers of smoking. This court's already written at length about it in Martin, so you don't need me to preach to you again about the evils of what they did. But certainly that's relevant evidence that the jury needed to hear. There was no objection. It was appropriate. There was not a tremendous amount of argument about it, but there was argument about it in reprehensibility and closing, and there was no objection to that either. So those issues are not preserved, and they are without merit in any event. The statute of repose issue, they are not asking, at least in oral argument, for review of the directed verdict. They're only asking, their argument is focused on the jury instruction. That's a good thing, because their directed verdict was not preserved. It was not renewed at the end of the trial, as was required by the rules at that time. So the directed verdict issue is not preserved. The jury instruction issue is preserved. They did request a jury instruction, and the law is if you request a jury instruction, it has to be given if you satisfy 3 steps. The first step is all you have to look at. The first step is the instruction has to be an accurate statement of the law. The instruction that they proposed would have told the jury that you may not consider evidence of alleged statements, concealment, or other conduct outside the repose period. That is not a correct statement of the law. The Florida Supreme Court in Cush said that the focus is not on reliance. I'm going to get to that in more detail in a minute. They're saying their whole argument is she relied outside the repose period. That's not the focus. The Supreme Court says you focus, for repose purposes, you focus solely on the defense conduct. When did the defendant commit the bad acts? The Lashkey case, which they ironically rely on for preemption, even though it was overruled by the Supreme Court in Carter, they don't address Lashkey, or they didn't at least in their initial brief, on repose. Lashkey was a cigarette case. It was about the same kinds of allegations of a continuing conspiracy over decades to conceal the health effects of cigarettes. And what the district court in Lashkey said was that the repose period does not begin to run until the last act in furtherance of that conspiracy. This conspiracy, this jury heard evidence that the conspiracy continued at least through 1999. In 1982, they heard evidence about a campaign, a big campaign at the time. They heard there was a little bit of advertising, very little advertising in the modern era. Most of it was what they were saying to the public, what they were saying to Congress. The Waxman hearings, there's evidence in this case. It was in the other 4 cases this court has heard as well. In 1994, they continued to lie to Congress about this, concealing these dangers. And the jury heard that it was not until 1999 in congressional hearings that they finally fessed up. So this was a continuing course of conduct. Based on the evidence, the jury heard plenty of evidence here, but it's not even a jury instruction issue. It's not even an issue in this case, because that was resolved in Engle. In Engle was where all of the conduct elements were determined. The Supreme Court says these conduct elements have been determined. They apply to the class members. We'll now have individual trials on the individual issues as to the plaintiffs. Statute of limitations, comparative fault, did they die from cigarettes or something else? Those are the issues that are tried now. Consistent with that, during phase 1 of the Engle trial is when the tobacco companies made these arguments. And this applies to preemption as well as repose. They made all of these arguments to the trial judge during the 1-year trial in phase 1. And at the end of the case, that was their motion for directed verdict was based on those issues. The trial judge denied them, explained why. I provided that in the appendix and in our brief. And he said, but you can renew it after phase 2 when we hear these individual defendants. Or he didn't say you can renew those particular. He just says you can move again at the end. And they did. After the 3 class representatives phase trial was over, they raised these issues again. And again, the trial court denied them in his order. In his order in which he denied them is the order that the tobacco companies appealed to the 3rd District Court of Appeal. On appeal, they abandoned repose. They did not argue repose on appeal. Instead, they argued preemption. And the third DCA did not address preemption, but it reversed the judgment on other grounds. The class took it to the Florida Supreme Court. Florida Supreme Court accepted jurisdiction. Again, repose was not mentioned anywhere. Preemption was mentioned in the answer brief by the tobacco companies in the Florida Supreme Court. The Florida Supreme Court wrote an opinion, explained why preemption doesn't apply, and they moved for rehearing. And in their motion for rehearing, they said, you didn't really address preemption enough. Let us remand it to the third DCA so they can address that issue. Florida Supreme Court denied rehearing on that ground, granted it on some others, so they were considering that motion for rehearing closely. Goes back to the third DCA. They asked the third DCA on remand, hey, let us brief our issues, including preemption. Still no mention of repose. Third DCA says no. Final. That's it. That's over. That issue's over. That issue's been decided. It's also been decided, even if it wasn't an issue of law of the res judicata effect of these conduct findings. Again, the res judicata effect is that the concealment and the conspiracy occurred. Those are the conduct elements. And specifically, the statute of repose was presented to that jury because if you look at the Engle verdict on, for example, the conspiracy form, the jury was asked for each defendant, did they participate in the conspiracy before May 5th, 1992, and did they continue after? That's the repose defense. If the jury had said yes before and no after, repose might be an issue. Repose would probably win. They didn't. The jury said it continued after 1992. So that ends the issue. Now, their focus, again, is not on the defendant's conduct. They ignore the fact that it's undisputed now that their conspiracy continued throughout the period, well into the repose period, at least until 1999. Instead, they argue, they ask this court to hold that you don't look at what they did. Instead, you look at what Ms. Clay did. And you look at when she relied on their misconduct. And they say because she relied on it, she started smoking before 1982, she's out of luck. The Cush case, the Lasky case, the Ambrose case that we cite all demonstrate that's not true. That can't be the case. And all you have to do is look at the facts. Look at the facts of Cush. Cush was a wrongful birth case. A doctor failed to tell the parents that they had a genetic deformity in there when he did a background check. And so they, after that period, that was outside the repose period. Within the repose period, they relied on that, got pregnant, and had a baby. And they sued for failing to tell them about this genetic defect. And the Florida Supreme Court says you do not look at the conduct, at the reliance. You do not look at what the plaintiff did. The repose period focuses on what the defendant did. And even though the plaintiff relied within and suffered the injury within the repose period, because the fraud in that case was just a one-time thing, because that occurred outside the period, Cush was barred by the statute of repose. Lasky and Ambrose are just the other way around. Lasky is the continuing, where it's continuing you look. But in the Ambrose case is just perfect, because the Ambrose case involved a continuing concealment. It was an adoption case where the adoption agency had a record that showed that the birth father had bipolar disorder. Yet they did not disclose that to the pediatrician or to the adoptive parents. And that when they gave the pediatrician the medical records, which did not contain that, that was the only affirmative thing they did, that was outside the repose period. But the 5th DCA said that was continuing because this is a concealment case, and their duty to disclose this information continued. When did it continue to? It continued until the time that the court approved the adoption of this child who turned out to have exactly that same bipolar disorder. And so they said, because you've made that representation that there's no problems, you had a continuing duty, and that duty went forward until the adoption took place, by which time it would be too late. You can't undo an adoption. And so the 5th DCA held that was not barred by the repose period, because even though the duty began outside the repose period, it continued into it. So,
Simple State Counsel, was the defendant's requested jury instruction on the statute of repose an accurate statement of the law?
it was not. It was not. And Again, let me read it to you. They only requested one repose instruction, and it was this: jury, you may not consider evidence of alleged statements, concealment, or other conduct outside the period. That's not an accurate statement of the law when you have a continuing conspiracy. Laschke holds that you can look at the evidence beforehand as long as it's a continuing conspiracy. The Engel jury found exactly that. They found the conspiracy began before 1982, continued after it. That's it. There are no other questions. We do have a cross appeal, but that only becomes relevant if you were to reverse, and as there are no colorable grounds for reversal, I'll let that go.
Thank you. Thank you, counsel.
Thank you, Your Honor. First, we did preserve the issue with regard to youth marketing at Volume 8, 1420. And that is cited at page 31 of our reply brief. That site, Volume 8, 1420 to 1456, is our motion in limine to exclude all evidence or references to youth marketing. And it specifically talks about this being admitted for purposes of punitive damages. So we clearly did preserve it.
Under applicable law, there's no need to renew that motion during the course of the
I don't believe there is, Your Honor. Once you've lost and the evidence has come in, it's fair game to argue, it seems to me. With regard to the instruction, counsel, his reading was accurate, but only a part of the instruction. The instruction we offered is as follows. In determining whether Janie Mae Clay reasonably relied to her detriment on any statement by defendants that omitted material information, you may not consider evidence of alleged statements, concealment, or conduct that occurred before the operative date. We submit that that is an accurate and fair description. In determining if there's been a concealment or a fraud, you may not consider statements made before. We would submit that's a fair instruction. With regard to the cases, well, let me start with Engel and whether or not Engel decided this. The important point here is that the issue of the statute of repose is an individual issue for each case. Phase 1 of Engel, where we first proposed this and argued it, was a common issue part of the case. We lost it there. We should have lost it there. It was dealing with common issues. We didn't appeal it from the common issue part of the case because I think we must have realized that it was an individual issue to be decided in each case, and Engel itself said you may renew it in the individual cases in Phase 2. And so it's impossible that Engel, in the part of the case dealing with common issues, can have finally resolved the statute of repose issues for every individual defendant any more than it decided it for the 3 individual defendants who were there in Phase 2. So the statute of repose is an issue that needed to be dealt with in each case. Now, with regard to the cases that counsel is relying on and does cite, and we talked about all in our briefs, the Cush case is a really interesting case for him to rely upon. The Cush case is a case where the defendant won, where the statute of repose was applied because that very unique statute of repose, normally statutes of repose are 12 years like this one, they're long, but finally they do give some repose. That was a case where the statute of repose was 2 years in a medical malpractice case, and it was shorter than the statute of limitations. And the court said, tough luck, that's the way the world is. That's what a statute of repose is, and it cuts off plaintiffs when it happens. It's tough, because you didn't even have a cause of action. But they said in Cush that's the way it is. The other 3 cases, Laschke, Ambrose, and McLeod, as I said before, are all cases where the trial court had entered summary judgment for the defendant on the statute of repose. And what the court was doing, though, in those cases was saying, well, no, essentially, summary judgment isn't appropriate here. And then they gave a rationale with regard to the continuing nature of the conduct. Now, the Ambrose case is very interesting, as counsel, I think, has accurately described it as an adoption where the statute of repose was applied by the trial court on the ground that at the time the parents received the child, they had received certain information, and they didn't get corrected information prior to the time of the actual formal adoption a year later. And the court simply said, yes, that continuing concealment, because prior to the formal adoption, the parents could have said, we're over. I think I realize my time is up. Thank you very much, Your Honor.
Thank you. Thank you all. The court is now going to take a 15-minute recess and invite you to have coffee outside the door.
Thank you very much.
Outside the courtroom.